Can you send it to me? Wait. When you get a chance. Can you send it to me? Yes. Can you send it to me? A little too sensitive. A little too sensitive. Yeah. It's very sensitive. It picks up everything.
Sorry about that. I don't know what's going on. Okay.
Carol, did you mute it?
Yes.
You muted it, but it was like,
It picks up every single.
Yep, that's just because it's the stream's live, so I'll just actually just close out of this.
Thank you, Brad.
You're welcome. Okay. Should we
did you get the link?
Okay, so what do we do? Anything?
I guess we don't even really need the sound on the TV anyway.
Okay.
With no one zooming in.
Right, you don't need to sound
Okay.
here. They can't hear that.
So you
Okay.
should go.
Okay, thank
You're
you.
welcome.
It's picking up every.
No, it was playing it back to you.
Yeah. It is just.
Are you ready?
Ready.
Sure, we have a plea on Anthony first. Good. Mr. Harris still has another question. Did you?
Yeah.
I thought you did, I just couldn't remember.
Morning, Your Honor.
Good morning, Mr. Harris. This is Anthony Fears, case B 21-02236. Just for the record, representing Mr. Fears today
Rodney Harris on behalf of Anthony Fears.
and on behalf of the state.
Leah Dinklocker.
All right, good morning, Mr. Fears.
Morning, Your Honor.
How are you doing today?
I'm all right.
All right, feel free to take down your mask if you want to. We need to hear you loud and clearly. Everything is being taken down by court reporter. All right, it's my understanding that you're going to change your plea from a plea of not guilty to a plea of guilty to a plea arrangement. Is that correct?
Yes, sir.
I have to ask you a few questions, so please don't take offense. How old are you?
39.
All right, how far did you go in school?
I'm 1 year to college.
All right, you're able to read and write?
Yes, sir.
All right, you're able to go over the plea form with your attorney?
Yes, sir.
He explained everything to you?
Yes, sir.
Do you have any questions regarding this plea form?
No, sir.
All right, the prosecutor is going to tell me the nature of your plea agreement. Then I'm going to come back to you and go over your rights and some other instructions with you. If you have any questions along the way, please ask. Is this a negotiated plea or is it
Yeah.
open?
No, Your Honor, this is a one count indictment and he's pleading as charged.
All right, is there an agreed sentence or a open?
There's not, Your Honor.
All right, thank you. All right, Mr. Ferris, you understand that a plea of guilty is a complete admission of guilt. And that once you're in a plea of guilty, after I hear the facts, I will find you guilty and sentence you accordingly. Do you understand?
Yes, sir.
Are you entering this plea voluntarily?
Yes, sir.
Have you been promised anything in exchange for your plea?
No, sir.
Have you been threatened or coerced in any way to enter this plea?
No, sir.
All right, you understand that you do have a right to a trial by jury. And that by signing this document and entering the plea today, you're giving up that right. All right, you understand you do have a right to require the prosecutor to bring in witnesses to prove your guilt beyond a reasonable doubt. You understand?
Yes, sir.
All right, you understand you do have a right to bring in your own witnesses to testify on your behalf.
Yes, sir.
All right, you understand that neither myself nor the prosecutor can require you to testify against yourself. You understand that this is a felony of the 4th degree.
Yes, sir.
That means I give you anywhere from 6 to 18 months in prison and a maximum fine of $5,000. You understand? Your attorney went over that with you. You understand that if I choose to sentence you to prison, once you are released from prison, you may have to serve a period of post-release control. Did your attorney go over that with you? All right, you understand that if you are placed on post-release control, the adult parole authority is authorized to return you to prison for 9 months for any single violation and up to a maximum of 50% of your prison sentence for all violations. All right, you understand that if you are convicted of a new felony while on post-release control, in addition to being punished for the new offense, I could add an additional 1-year consecutive prison term or whatever time remains left on your post-release control term, whichever is greater. He went over that with you, I'm sure. I'm sure he also told you that a prison sentence is not mandatory, that I could choose to place you on community control, which is more commonly known as probation. Right, he went over that with you as well, correct? All right, if I choose to place you on probation, you have to abide by all the terms and conditions of your probation officer. If you fail to abide by those terms and or conditions, violate the law in any way, or leave the state without permission, I could modify your sanctions, continue your sanctions for up to 5 years, or impose that prison sentence anywhere from 6 to 18 months. You understand?
Yes, sir.
Do you have any questions?
No, sir.
What is your plea?
Guilty.
Agree?
On or about April 20th, 2021 in Hamilton County, state of Ohio, the defendant Anthony Fears, while operating a motor vehicle, recklessly caused serious physical harm to Charlotte Taylor.
Nothing on this fact.
Finding is guilty. Are we going to waive PSI?
Judge, I will be requesting the PSI.
All right, did you
Like
get
the sentencing date of March 10th, if that's okay with you.
March 10th is a good date? Okay.
And a
Anything we
victim-
need to discuss before?
I would just be asking for a victim impact statement as well.
All right, so we'll do a PSI victim impact statement. He's currently out on bond, correct?
He is, Your Honor.
All right, the bond will remain the same.
Thank you.
Anything further?
Nothing further.
Okay,
this time.
thank you.
All right, thank you. Here, here. Today is what, 13th? Thank you, sir. Randall Smith. Is Randall Smith here? Yeah.
This is Mr. Barrett.
Where's Mr. Theodore? You're Paul Barrett, correct?
Yes.
Paul Barrett.
Really? That's what they. that's what
So
they
we have
told
a Barrett and a Barron.
Oh, that's where the confusion might have been.
Yeah.
I think we were waiting on Wayne Barron.
Gotcha. Well, I got up to Jack's, they said Barrett, so I can take him back up. I'll be back.
And we bring down Barron.
Yes, sir.
Sitting by my clock, and I was like, well, I'll double check.
Come on, let's go. Is that to me? Oh, no. Okay.
Yeah, my wife said
She's still like,
she got to see if they're,
okay.
they're. Did you hear from, Mr. Witt? Mr. Hickenlooper, do you have your disc ready for
I do, I have a,
flash drive?
I have a flash drive that we can use, it's got the video and the files with photos, I think you already have the photos, and
Video.
Mr. Geis is here, he's got what I believe are the same photos, so that might be an easier way to do it. I just need to try it out, make sure it can play on
Okay,
this,
I watched the video.
and we, Mr. Geis are asking that we play it.
Okay, that's fine.
What is it? Do you know how to use it? I just need to plug this drive
When
in.
you bring it up, you need to share a screen.
Okay, there's share screen. Do we have a mouse?
Yeah, this is it right here. This is it.
Oh, okay, okay, I got you.
So I guess you plug it in the back. And you should.
Take off the sunglasses.
You can probably just plug it in right there, right? Yeah, I would think, just wherever there's a USB. I would think you would just plug it in.
Okay, let's do that. Yeah, second.
There you go. There you go.
Share screen.
Let's make sure it closes.
Yeah, good stuff. So work it out.
Are we, we have both witnesses.
The witness from the first theft is not here.
All right, I read her.
But Mr. Geis is here. Mr. Geis will address the court. His brother would like to address the court. And then I have a police officer here as well. In addition, I think all will reinforce the attorney's been in this court right now.
Okay.
They brought the wrong guy up.
I'm sorry.
That's what's very, that's on the notes, you know, the roads and everything. It's just like- That's what. And that's what. It's a damage, which is apparently tested in another case. I got this.
No, sir. I didn't talk
Morning, Mr. Witt.
We're ready whenever you're on.
there's nothing I can talk about.
All right, calling the case of Wayne Barron. This is B 2105-373. Representing Mr. Barron today
Scott Crystal from Mr. Barron.
and on behalf of the state.
David Hickenlooper.
Mr. Barron is here for a bond review, is that correct?
That's correct, Your
How
Honor.
many cases does Mr. Barron currently have?
Currently has two cases, Your Honor. The case numbers B 2105-373, which we had a bond hearing, I believe the last time we were here back in November, and he went out on the box. The second case that filed the motion for is B 210-6455, A is an apple. I'd like to address that case, Your Honor.
So what is his current bond on B 2105-373?
I believe it's 50,000 spray.
Your Honor, showing on 5373. That bond was modified to OR EMD lockdown, and that would have been on November 17th.
That's correct.
And he was on OR lockdown, and I guess got the new case.
That's correct.
So he picked up a new charge after I gave him an OR bond?
Well, he did pick up a new charge, but if you look at the complaint in that case, it happened before the complaint in the 5373 case. I've got both of them right here. I don't know if you'll be approached to show you.
Yes, please.
So the first case is 5373. That's 1019. The charge was occurred.
Okay,
And then on the second case, as the complaint states, it occurred on 10/10. What apparently, and I filed the discovery, I don't know the answer to this yet, but apparently Mr. Magnus has co-defendants, and I believe, all I know is that a DNA test was apparently done on a gun, and then through maybe their search of database, they said it came back to my client's DNA when they tested. That's all I know at this point. So therefore, he didn't violate any of the terms of his bond that you had put him on. It just is a charge that somehow came up that we don't know anything about. But it's per the complaint, it shows that I think they didn't understand it. I wasn't in room A when they came through to do the bond on the sheet. So it says mistakenly that this was as a result of an EMD search, which it wasn't per the bond, I mean, per the complaint that Your Honor has looked at. So we think that there's no, the reason for the high bond, it doesn't appear to be correct, and we just believe he should be restored back onto EMD as he was in his compliance.
it looks like they just added on the weapons under disability to go along with the carrying of concealed weapons. Is that correct, Mr. Prosecutor?
On 5373, Your Honor.
On 6455.
The 6455, that is a new case, and actually I don't even have that jacket yet. I'm not sure what the indictment date was, but it was probably pre-indictment at the time of the last bond hearing, however.
I'm sorry.
No.
I think today, that case, the new case 6455 set for DSC. Just so that I'm clear on that, but
Yes, that's what I
That
was
may
up
be
for.
getting processed into our discovery. At this point.
And what is the bond on 6455?
I think it's 50,000 straight.
Plus any-
Plus EMD.
Looks like 6455 was actually indicted on December 30th by the grand jury in Hampton County. I think we would be opposed to the lowering or modification of the bond at this point on either of these cases. The first thing is that the weapons under disability involved in both cases. Certainly, there was an awareness on the part of the defendant at the time that the bond was set in B-21-5373 that this other case was out there, just hadn't been indicted yet. And then I don't see anything in the notes where the prosecutor was aware that that was being presented at that point.
So these two weapon charges occurred on different days.
That's what it appears to be.
Is that correct?
Correct. And the charge that we're here on today, 6455, was previous to the original case that you had put him on a ORNP bond. Again, I believe that when they were setting that bond, based upon the notes I received from May, they thought that this was happened after, I guess, the original charge and or had something to do with an EMD service.
What are the 2 dates of the offenses?
Your Honor, on 216455, October 10th, and then on 215373, it's October 18th. So a little over a week.
So a week later, he got caught with another gun. Is that what you're telling me?
That's what it appears to be.
I believe, no, he didn't get caught with a gun. They tested it. If you look in the information I have received, the limited information, it says, if you want me to approach, I can show you, but it says per officer investigation and DNA evidence. So he wasn't found in possession at that time
On the 10th.
on the 10th.
And I'm talking about on the 18th, that involved a vehicle.
That's technically the 19th on the complaint.
I just so everyone's clear, let's talk about what case we're talking about. That way, you know, we know what date, what incident. Otherwise, it's kind of morphing into one event when it's really not.
It's 2 guns on 2 separate dates.
Correct.
They found the
10,
gun
19.
on 10/10. They tested the gun and found his DNA upon the gun. And then they brought that charge after he had already been indicted on the other charge.
And then we already had a bond hearing and everything.
So the DNA testing on the gun on 6455, October 10th was done. We were probably waiting for those results to present it on the 18th into the 19th or 18th, 19th of October. That was a separate incident. The way I'm looking at this,
Okay.
on B-21-5373.
Mr. Magnus, you look like you have something to say.
As to the bond, no, I will just point out that presence of DNA does not show when it happened. That the fact they found a gun with DNA on it, we can't tell whether any possession of that gun was before the statute of limitations, before the disability was created, and on or about the day charged. I think they're gonna have problems with those charges just on that basis alone.
They just
I find
found
that
it somewhere in a car, correct? But he was not in the car.
I don't know exactly where they found it. I know, my understanding is they found these guns and no one was present.
The other gun was found in the car in a separate case. Just
On the 18th, 19th.
I mean, frankly, it's the same date. I'm trying to figure why the 2 defendants were indicted together. It doesn't appear to me that there's any factual connection since they're not in the same count, but that's not something for the court to deal with today.
All right. You still have the same address?
Yes, sir.
Who do you live with?
My mother.
All right. Is your mother here today?
Yes, she is.
Where is she?
She's standing up.
Come on up, man.
Cheryl Meadows.
Good morning, Ms. Meadows.
Good morning.
How are you doing today?
Okay.
So your son has been staying with you?
Yes.
He has not been out of the house in the last couple of months?
Nope, I work from home.
You work from home and you're able to watch him? Because I put him on EMD lockdown. I don't show any violations that he's ever left the house in the last 2 months.
Yes.
Okay. All right, I will reinstate the bond to OR EMD lockdown. He is to remain in the home until his trial date. Are we setting this for trial or are we still in the pre-trial stages?
But just for this first case, this DSC, I need to speak to Mr. Magnus too, and then if we can decide that after this hearing.
Okay.
Your Honor, I mean, I just filed for discovery yesterday, I definitely not ready to schedule a trial.
Yes, sir. I'm noting your objection.
Your Honor, I was just to say, we would object to the lowering of the bond. We would ask for the bond, the original bond on 537 to be reinstated, and that was 125,000 straight. With the MD.
Well, considering that he has not been out of the house in the last 2 months, he has been in compliance with the EMD lockdown. And on the second case, these guns were found with no one present. It was just DNA evidence. So I will allow a bond.
Thank you, Your Honor.
So,
Yes. objection for the record.
objection, Your Honor.
Yes, sir.
You guys have a date. Well, are you gonna file?
I think that's a reasonable possibility. The drug charges. The drug charges. are the big issue, I'll be honest. I won't know if it's not one of these.
Yeah. I saw.
Yes, please.
I'm the one.
Mr. Witt, you want your client next?
Anyway, I want to talk to you.
We can wait back. Right?
I think that's all our complaint.
You can tell them.
Yes.
Talk to Jeff. Jeff, I got like 2 minutes. So,
Yes, ma'am.
That's right. How do we clear there?
Any day that we except Thursday, is good for me. Thursday, not bad.
Yeah.
Mr. Ewing,
Yes, sir. Morning.
what are we doing on Parsons?
Oh,
I want to speak to David about it. Might be able to resolve it, but I don't know if Mr. Nathan Lippert has the files. So he's looking for it before it's due to Mr. Wood. Can resolve it, that might understand. Maybe try to get a little percent.
Yeah, I mean, I think.
Is Randall Smith here yet? Randall Smith? Barrett. Terrence Ghost in here. Anything on the You ready for your client to be brought down?
Here's what I want to do, Judge. I don't know. We get a coordinator next Thursday.
Okay.
So I'm just gonna set it. Thanks.
ARTON.
I'm not, he's coming back. I'm gonna go up, tell him to get back.
Okay.
I'm coming back Thursday.
So
Okay,
he's
Judge.
gonna not,
Yeah.
So which one? Which one is that?
this is on David Martin, Your Honor.
This will set up Thursday. That's what's set for next.
So this is David Martin, B 2104-134, representing Mr. Martin today.
Yes, Your Honor, Jeffrey Wood.
All right, and on behalf of the state.
David Hickenlooper and.
Renee Hellman.
She is the victim in this case.
Okay. This was set for a bond hearing, correct?
Correct.
But you want to hold off on it here?
Yes, I need to talk to him and set up, we can coordinate next Thursday, the 19th. So we're gonna keep that.
All right. So the bond will remain the same until next Thursday?
Yeah.
Ma'am, anything you want to say?
I'm glad he's not getting out today. Protection order means nothing to him. He looked at his past, he's had a bunch of them, he's violated all of them. And I'm scared to death he's gonna show me something. Somebody show up at work. Threatened me to drop the charges or I was gonna get hurt. Just threatened my 26-year-old son, who has a 3-year-old daughter, granddaughter. It's just an ugly vicious cycle. I pull in my driveway and look around, scared to death to get out of my car. And this just hasn't stopped.
Okay, you'll be back next week. All right, thank you very much.
I believe we've notified her for next week as well.
Yes.
What's that?
We've notified this gentleman for next week.
Okay. Thank you, Judge.
All right, thank you.
Thank you.
Thanks.
The 20th?
today.
You're Sean Barton Jr.,
Yes, sir.
correct?
Yes, sir. How you doing?
Doing great. Good morning.
Good. We file a motion on response.
Yes.
What you said? Are we ready on Mr. Bennett's case?
Our part of it is ready, Your Honor. I don't know where Mr. Bennett is.
He was in the hallway. Can you check the hallway? I did. Sorry.
Saying there's two more.
I don't see Mr. Bennett.
And the court date is put on, it should be 2 January 7th. Instead of what's occurred.
I don't know.
You know, it's 1 o'clock.
Just for a minute.
I can't address that today because there's a burglary. I mean,
Big doctor.
Okay, that's fine. That's fine.
tomorrow. We got all our other dates.
Every other case we have.
You ready to bring your client down, Mr. Bennett? All right, we'll bring it down.
Take Mr. Carter back. That'll be tomorrow, okay?
So he's going back to bring down Orlando Saints.
Orlando Saints.
Yes, ma'am.
So he's done for the
He's
day.
finished for the day. He'll be back tomorrow.
Okay.
Thank you.
Yes, sir.
Appreciate that. He was probably already
He
trained.
was. He was in January. Yeah, so I don't know.
Yeah. one back there. Yeah.
Did he even hear the-
Not a problem.
I know. So she knocked it over some. Okay.
So that was Ally Coulter, just continuing that until the 20th. Randall Smith, calling again, Randall Smith.
Randall Smith. Randall Smith. Randall Smith.
You have grand jury today?
Oh, no.
Okay. Just making sure.
Yeah, it's scheduled unless someone did it for me. If they did it for me, they didn't come.
I'll give you two good cases. Two cases. Good documents.
Yeah, he already put the date of the 28th on Friday's cases. St. Clair.
Oh, we're not doing St. Clair. We're not doing St. Clair.
It was, yeah, it's a toss-up.
Oh, okay.
It's in James. I don't know why. I think it's one of those like mental tics or whatever. Yes.
Yeah, this is the board.
Mr. Guys, do that board that you're gonna use. I'm bringing it up now. If you stand here, you can face that. See it, that's right.
Right.
And then.
I'll be able to see it on my monitor.
The court will be able to see it too. Okay. It's the same thing.
Look at mine. Mhm.
This one is, this is your taxation.
Yeah, but it's gonna be on the forms. Right. Oh, yeah.
So times perfect.
All right, calling the case of Orlando Saints. Can you put cuffs in front? We're gonna need to sign a few documents. B 20-4791, representing Mr. Saints this morning
I bear on behalf of the section.
and on behalf of state.
David Hickenlooper.
All right, Mr. Saints previously entered a plea to 3 counts of the indictment, is that correct?
Yes, Your Honor. He entered a plea to count 1, which is theft of a motor vehicle felony 4th degree. Count 2, aggravated robbery, felony of the 1st degree. And count 4, felonious assault felony of the 2nd degree. The counts 3 and 5.
Thank you. And these were 2 different victims.
Yes, Your Honor. Count 1 was a victim that had her car stolen previously, and then counts 2, 3, 4, and 5 all relate to Mr. Geis.
All right, thank you. Good morning, Mr. Saints.
Good morning, sir.
All right, so I need to go over a few things with you before we continue with your sentencing hearing, okay?
Yes, sir.
The first thing is, last time you were here, you were a little hesitant about your plea. I remember speaking with you about that, so I want to make sure that you are entering this plea voluntarily
Yes, sir.
and that no one has threatened you or coerced you into entering this plea,
No, sir.
and no one has promised you anything to enter this plea, correct?
No, sir.
All right, so the charges that you have pled guilty to and you were found guilty to require a mandatory registration as a violent offender. Did we go over that form, Mr. Bennett?
Yes,
I believe we did, Your Honor, and it was also included in the plea form, and I believe that box was checked.
All right, so I want to make sure that we went over the form with your client, but he did not sign the forms. I don't have signed forms yet.
we went over, Judge. I thought he signed it, but I did discuss it with him when we reported on.
We may have, but I just want to make sure he signed the forms before we proceed.
There, abundance of caution, we can go over the actual form today, and then go ahead and have him execute that same form.
All right.
Well,
Move over there very quickly now, since he's already actually heard the form, and we went over the form. You're required to register every year once you are released from prison. You understand that? You are required to provide the sheriff certain information, including your full name and any aliases that you use. You're required to notify the sheriff of your address, your social security number, driver's license, commercial driver's license number, any state identification cards issued to you. You need to provide the name and address of any place where you are employed, any place where you are attending school, any place where you live. You understand? And you're required to register every year. You're required to register your license plate number and any identifying information of the vehicles that you are driving. You're also required to give any personal descriptions such as scars, tattoos, and distinguishing marks on your body. You're required to provide the sheriff fingerprints and palm prints, and they will take a photograph once you are released. You understand? And after your initial date of registration, once you are released, again, you are required to register annually. You have any questions?
No, sir.
All right. Mr. Bennett, you want to approach? Yes, the documents need to sign.
This is the same thing we discussed the last time.
Mr. Bennett, do you want the state to go first in sentencing, or do you want to go first?
The state will go first.
All right, thank you.
thank you, Your Honor. We've been here, these are very, very serious matters. I have here in court today, and I would like to have address the court, the victim, Mr. Geis, Officer Goldschmidt, and then Mr. Geis's brother is also present. I'd like to address the court at the appropriate time. What we have here and what the state's position is on sentencing is that we are seeking a term of not less than 19 years in this matter. We believe that obviously the count one and the other counts can run consecutively, but in reviewing 2914 and the Ohio Sentencing Commission's guidance from the Supreme Court, when you have a single course of conduct resulting in two offenses, and if it is of serious enough nature, and that one single term will not be sufficient to protect the public, punish the offender, then consecutive sentences can be used prior, provided the court makes the proper findings. Specifically, the court if the and our position would also agree with this, is that a minimal or concurrent sentence would demean the seriousness of this offense. And then if the court makes a finding, and we would ask that it does, that two or more multiple offenses committed out of a single course of conduct, in this case aggravated robbery, felonious assault, the harm is so great or unusual that a single term does not reflect the seriousness of the defendant's conduct. Well, and that's what we're really getting down to at this point. That the harm in this case was so great, so serious, so unusual, that it demands the consecutive sentences and demands the sentences amount or in the term that we're asking for, not less than 19 years. At this point, what I would like to do is play the video of incident involving Mr. Geis at the car wash, Zip's Car Wash.
All right,
So if you
where
do-
is Zip's Car Wash?
It's in Colerain Township, Your Honor.
This was a series of carjackings at that Zip Car Wash.
It was, the first victim, I believe, had happened at maybe another car wash.
a different one.
But the MO was the same a few days prior. Approached the victim in that case, took her car and removed it. At one point, he indicated to that victim that, well, the cops can't do anything to me anyway. In this case, at Zips on Colerain Avenue, it was again the same MO. There, individuals are there. They're cleaning out their car, using the vacuum. Doors are open, and then he approaches. And in this video, you'll see him approach the manner in which he approaches, and then take the car. So what I would like to do now is play that video.
Okay. Did you click share screen so it'll pop up on my monitor?
I thought I did.
Okay.
Your Honor, I'll pause it for a second. Is it playing on your monitor?
Oh, I didn't.
It says no screen share.
It says well.
It says you are screen share.
It says new share, so it says I am screen sharing according to this.
Yes, I'm good. Go ahead.
Okay.
Oh, yeah. Now, I noticed in the video that there was another car following. Is that someone else or someone that was with the defendant?
Your Honor, I believe that car was trying to follow follow the defendant to, they'd seen what happened, tried to intercede. You may notice that there is a truck that tries to block his way. The defendant has to back the CRV back up over the curb to avoid the truck because he was trying to box him in. It was very apparent that one, he, that being the defendant, was trying to escape at that time. Then, what happened is, if the beginning, before, as he goes to the after he's run over Mr. Geis, goes to the right of the screen. That exit was closed or blocked, and he had to come back. Before he proceeds to that right side exit, he stops. He stops, he looks, he realizes what he's done. And instead of rendering aid, instead of calling 911, instead of doing anything, he comes back and continues with his escape. Now, the injuries. Yeah, just, we're gonna let you guys. So obviously, Mr. Geis remained in that position until the fire department and paramedics arrived to take him to the hospital. The extent of his injuries were extreme. It went from his feet all the way to his head. And we're going to have Mr. Geis kind of describe exactly what he's gone through since that time and what he still has to go through because he's not done yet.
Now, Mr. Geis, I did read the report, and one account indicates that you actually died and they brought you back. Is that correct? All right, so go ahead, tell me what you want to tell me. Take your time.
Oh,
You
to tell you about when they
Tell me about everything, whatever you want to tell me.
Now, I will say, since this accident, Mr. Geis, you've had some difficulty organizing thoughts. And you need to work off of stuff you write down ahead of time or write down to recall. Is that correct?
yes.
And then you've also had some not obvious physical injuries, but also some emotional trauma as well.
I don't know if anybody can see these, but
And Your Honor, I believe these are also included in the PSI.
I have those pictures as well.
Your Honor, I'm gonna start off with, I survived cancer and I was celebrating a huge victory. Second thing I know, I go to the car wash, was acting out my car. The next thing I know, I was in a fight for my life in my car. What I remember next was I was in the ER with tubes in my throat, level 10 pain all over my body, head to toe. I could not breathe without extreme pain all over my body. 12 broken ribs, 2 punctured lungs, could not see out of my right eye, broken orbit around my right eye, permanent damage to my right eye after 7 exam tests, broken jaw, broken collarbone, damage to my right shoulder joint, 18-inch laceration from my front left thigh over my knee and beyond. Tore my kneecap out, degloved the skin off the back of my knee down to the ankle, had to have skin grafts from my thigh to my back of my leg of my knee. Extremely painful skin graft where they put the donor skin back on the leg and they have to take it off 3 days later, and they let it go a day and a half too long, and they almost had to take me in the OR to do it. Lacerations on the back of my head, disfigured facial skin also on my left arm and on this side. Spent 21 days in ICU at UC. They overdosed me in the ER on fentanyl and I was coded again and was brought back to life. And Narcan drip for 12 hours. Had 2 chest tubes in my lungs to excise blood from my chest wall so I could breathe. had to take serious sleep medication and pain medication, have to take serious sleep and pain medication daily. I've had to change my bandages on my left calf 2 times a day since the assault to the present. That's 515 days from September 20 to September 21. That's 1 year. And then October 21 to January 22. I had my left ear sewn back on. I have to have surgery on my collarbone to put it back into place. Your Honor, his crimes do not carry a mandatory sentence. However, I will have to have a mandatory sentence put on me for the rest of my life, mental, physical, and financial. As a result of this violent, careless act he put upon me, I am requesting the court to impose a $25,000 restitution and towards future medical things I have to have. My wish for you, Orlando, is to pick up trade or craft, sir, while you're incarcerated. So you're gonna come out a better person than when you went in.
Yes, sir.
And a little footnote, lose the friends you had before you went in.
Yes, sir.
Because they were running you down the wrong road.
Yes, sir.
Thank you, sir.
I wish you well.
Thank you.
Officer, tell me your name for the record.
Chris Goldschmidt.
Your Honor, I believe his brother is also present, and maybe you have his brother.
I'll have him do the last.
Okay, very good.
I don't have a whole lot to add on to it. I agree with Mr. Hickman through what he recommends, and working with Mr. Geis, when I was first assigned this case, we were kind of working it as he did not make it as it looked, and it took about a week or two, I think, before I could even talk to him because of what was going on with him. He's been great to work with. It's sad to see a truly victim in this crime. He was just trying to clean his car. Could have been any of us. That's all I have.
All right, thank you.
Your Honor, I believe Mr. Geis' brother is present as well, would like to address the court in addition, and then I have a couple more things that I would make the court aware of.
Yes. Tell me your name, sir.
Gary Geis, Your Honor.
Yes, sir.
This is my brother. There's 5 other ones, but he's my best friend and my brother. He hasn't been the same since all this happened, and he's never going to be the same again. It really ruins his life, and there's nothing more I can say about that, than
You actually wrote me a letter, correct?
I didn't. I wanted to come up and speak.
Well, I think several family members wrote me
My
letters.
brother did, David.
Your other brother,
We
okay,
got 9 brothers and 10 kids.
okay. I remember a letter from a brother.
And so he's my best friend and he's my brother. And every day I talk with him, he just isn't the same person.
Thank you, sir.
Thank you.
Your Honor, one of the, and while there may have been some contriteness in court, one of the things that we look at when we're making a determination, what we ask for is remorse. What I'm particularly looking at in the remorse is what we saw in the video, where after he runs over Mr. Geis, he stops, he looks, and it does nothing. Continues to try and leave. Goes back past him, still lying on the ground, backing up, maneuvering around other vehicles that are trying to stop him from leaving, and still doesn't render anything. Now, Mr. Geis, you have a number of medical bills. You've had multiple surgeries. You still have to go through surgeries.
Medical bills. I had
What-
surgery on my collarbone, more likely on the back of my knee and on the shoulder.
And so what is your out-of-pocket expense for the surgeries up to this point?
I have it tabulated. Thereafter.
Did you tell me an amount this morning approximately $24,000.
Yeah.
About that. So far.
That's just out of his pocket. I'm sure the medical bills are well over.
I'm
$1
sure
million.
that,
Over the
Medical
course
bills
of
are
15
expensive.
months.
Right.
not to mention, this was not the first time he stole a car during this period of time. So the court can also look at this as a continuing course of conduct. The same memo, the one that, thing that is most notable is that in this case, and this is where we get to the felonious assault, is that the car was turned into a weapon, into a deadly weapon. As you heard today, during this, Mr. Geis died, coded, however you want to characterize it, multiple times. It looks like, that would also be a basis for a consecutive sentence, is that we have two charges arising out of the same conduct, but with different elements and additional elements from each other. I think in the interest of justice, in the interest of community, and in the interest of really the fair and equitable thing to do is that the court imposed that 19-year sentence. Mr. Geis, how old are you now? Mr. Geis is 65 years old. In 19 years, I'm hoping Mr. Geis is still with us. But during that time, he is going to continue to suffer.
So just for the record, he's looking at anywhere from 3 years to 26. Is that correct? Is that my calculation?
If you're adding
Minimum of
Reagan
3.
Tokes, yes.
Minimum of
Already
3.
in total, yeah,
Right.
correct, with 19 to 26.
Right.
It's 20 and
3
a
to
half.
19 to 26, correct. So you're breaking token.
Okay.
Correct.
Go ahead. I'm sorry to interrupt.
Yes, sir. In 19 years, Mr. Sanks is still going to be a young man.
You're 24 now?
Yes, sir.
Okay, go ahead.
But he will not have had to go through what Mr. Geis has gone through and will most likely go through in the interceding period.
Thank you. I'll allow you to speak again if you need.
Thank you.
This is,
Mr. Bennett?
I'm sorry.
He still wants us.
Your Honor, this was taken 2 days ago. That's still a wound on the back of my leg. I guess.
So that's Mr. Bennett. Are you can hand it to him? Mr. Bennett, I reviewed my cases very thoroughly. And this is the first time that Mr. Sanks has appeared in court, correct? This is his first set of charges on felonies?
That is correct.
All right, go ahead.
Judge, the first thing I want to say is this. Mr. Geis, I'm sorry, and I can tell you from speaking to Mr. Sanks, since he's become lucid and no longer under the mental impairments and conditions that he was under at the time of this incident, happened, this tragic, horrific incident. He's sorry. I can also say mother, grandmother, they're present. They're sorry. So there is remorse in this case. There is remorse coming from the defendant, myself, and also his family. I'm representing Mr. Sanks, so I'm going to speak on his behalf. I don't want to offend you with what I'm saying. I'm sensitive to your situation, and I know you've been through a lot. With respect to the Hamilton County prosecutors, and I'm speaking to the judge now, Hamilton County prosecutor, not you. So, with respect to the Hamilton County prosecutor's office recommendation for a 19-year sentence, I think that's vindictive. I think that's draconian. I think it's inconsistent. More importantly, it's inconsistent with Ohio law with respect to sentencing. It's inconsistent with it. And I'll show you why. I'm not debating or arguing. I have to represent my client and tell you what I think the law is. A 19-year sentence is not fair, and it is not equitable The law says fairness is justice. That's the true application of the law, regardless of consequences. Follow the law. And what does the law say in this case? I think the law says that he should get the minimum concurrent sentence based on the law in the state of Ohio, and I'll spell that out. But before I do that, I want to respond to some things that not Mr. Geis and not his family, but that Mr. Hickenlooper said with respect to sentencing.
Before you get there, I don't want to interrupt you, but you're saying that the minimum sentence, what is that minimum sentence you're referring to?
The minimum sentence is 3 years.
Okay, go ahead.
If you receive the minimum, and I'd be remiss if I didn't say this. If you've never been to prison before, never been convicted of a felony, and you get a felony, and it's presumed that you go to prison, it's not mandatory. Number one, you don't have to go to prison. But number two, if you do go, it's presumed that you get the minimum, unless that presumption is rebutted. And that is because legislators have said, if you've never been to prison before, you don't know what it's like to respond to the Ohio Department of Corrections. So what we're going to do is we're going to give you the minimum sentence on this felony for a term of imprisonment in prison. And we think that that is going to suffice to accomplish the purposes of prison, which is deterrence, punishment, and rehabilitation. We think since you've never been here before, you should get the minimum, which in this case, on aggravated robbery would be 3 years, on the felony assault would be 2. And then on the theft case, I believe that's a 4th or 5th degree felony. So the minimum would be 3. That's what our legislators have said. That is the law. That's not emotion. That's not bias. That's not hate. And that's not vindictiveness. That's the law. The law says he should get the minimum. Now, I talked about remorse, and when you're committing a crime, you're not remorseful, and you're typically not remorseful after. He's showed remorse. It's documented in the precinct's investigation report more probatively and more accurately with respect to what should happen to him today. The man that stands before you now is not the individual that was suffering from schizophrenia and that was bipolar. That's documented in the court clinic evaluation. So this is not just me saying this, that's documented in court records. He was evaluated by the court clinic for not guilty by reason of insanity. He was not determined to be, he was incompetent at one time. His competency was restored. He was incompetent, and the incompetency was bipolar and schizophrenia. That's very significant. So to say to a person that has been taking medication, that has that type of mind, that type of diminished capacity, wasn't remorseful. I don't necessarily agree with that. The last thing I'll say with respect to my rebuttal to these specific comments by Mr. Hickenlooper is this. Now, you saw the video. He's 22, 23 years old. 22 at the time. He stole a car. To say to you he should get 19 years because he used that car as a weapon, that's disingenuous. It's clear he didn't use that car as a weapon. What he did was he stole a car. And when you steal a car, you should be aware of the consequences that you may hurt somebody if they're trying to get the car and you back out and the car hits them, they fall to the ground. You should be aware of your consequences and you should be punished for your consequences. But in this case, you're not dealing with a person that is in his right mind. And again, that's documented because he was incompetent with those aforementioned medical infirmities and conditions. So is he in that car and using that car as a weapon? And clearly he is not. If you look at that video, he's trying to escape. He's trying to do 2 things. He's trying to steal a car. He's trying to get away. Now, if he stole that car and Mr. Geis or somebody else was saying, hey, stop in the front, and he just ran over intentionally or knowingly, that's different. In this case, I don't think you can tell from that video that he was, I don't think the video indicates that he's using the car as a weapon. And again, Mr. Geis, I don't mean to sound insensitive. I'm just trying to do my job. We are aware, we are sensitive of what you've been through, and we're sorry for it. But I just don't think he was trying to hurt Mr. Geis at the time. I think he was trying to steal his car. So what a lot of people will do is instead of looking at the defendant's mind when he's committing a crime, they'll look at the result, which the law says you can't consider but then it becomes inflammatory and sometimes people are provoked to ask for things that are inconsistent with the law, like 19 years, complete max. I want to put that 19-year request in context with respect to the law in the state of Ohio and the law in Hamilton County. Got about 10 or 15 murder cases in the state of Ohio right now. Probably 7 or 8 of them are from Ohio. Excuse me, are from Hamilton County. I routinely, when somebody tries to kill somebody with a gun or shoot somebody or rob somebody, people routinely on a plea, when they've accepted responsibility, this is known about this building, that people will typically get between 10, 11, 12, 13, 14, or 15 years on a murder. When they try to kill somebody and kill somebody and was successful at killing somebody, that's what people get for murders in this building. I've gotten plea bargains a lot less than that. Every case is not the same. I'm not saying that those cases are like this. What I'm saying is those cases are the most serious felonies in the state of Ohio, and people are getting less than the sentence that he's asking for on a plea. Specifically, what does the law say? You got to look at the sentencing factors. The purpose is to protect, the purpose of giving somebody time or sentences. We're trying to protect the public from a future crime by this defendant. We're trying to punish the defendant. How long have you been in jail already? So he has been in jail.
484 days.
And if he goes to prison, that's going to be punishment. I think rehabilitation has occurred because he's lucid now, his competency has been restored, he's no longer under that deprived, troubled, sick mind that he was when this happened. And I don't think he will reoffend. How do we know that he won't? Well, the experts who see cases like this time and time again, Hamilton County Probation Department, they looked at him, they looked at the case, they read everything, they looked at what he did, they studied him, and they came to the conclusion that, probation was a recommendation for the Ohio assessment system. That's documented in the PSI. They said regular supervision. I don't think recidivism is likely in this case. I think this young man can be rehabilitated with the minimum sanctions, which is, of course, a fundamental tenet of the law in the state of Ohio regarding sentence. The law says that what you want to do is to make sure that the public can be protected from the defendant and that the defendant is punishment, but you have to do so with the minimum sanction because they don't want people to unnecessarily be in prison for ungodly draconian amounts of time, like what is suggested in this case by the government. I think 19 years, I think that's arbitrary and capricious. I think 15 years, 10 years, those type of numbers that's just extracting vindictiveness. And I think that's an inflammatory reaction to what actually happened. And I'm not devaluing what this man has went through and will go through for the rest of his life. Conduct less serious when you look at the sentencing factors. Are there substantial grounds that exist to mitigate, his conduct? Did something potentially cause him to do this as compared to just being an evil, wicked man who's been in prison before, who's done dirt out in the streets, who's done all kinds of things, and this is the 5th or 6th time you got a felony, this is the 3rd or 4th time you're in prison? That's the man that should get a bunch of time. But the law says it's a less serious crime if there's substantial grounds that exist to mitigate your conduct, but it's not a defense. That is this case. Is bipolar schizophrenia and not being medicated clearly gave rise to this crime. And that was documented when he was evaluated for competency by the court clinic. Is he not guilty by reason of sanction? No. So it's not a defense, which is not guilty by reason of sanction, but does it mitigate what he does? Clearly it does. Clearly it does, and I'm not gonna keep beating on that. Recidivism, less likely factors. So if you're looking at 3 to 11 years, or 2 to 8 years, and you've been to prison a couple of times, and you got a bad record, you don't get 3. You get 4, 5, 6, 7, or whatever. You don't get 3 years. You're not entitled to that. You're not entitled to that because the law says you're not. Because recidivism is probably more likely because you've been in trouble before you didn't respond or react to prison like you should have. So we got to give you more than a minute. That's not the case in this case. Recidivism, less likely factors, 23 years old and it's happened. Insufficiency, mental insufficiency, very little criminal record, a misdemeanor theft offense, really no contact with the court. He had been law-abiding for a significant amount of time, yes, his entire life, except for 2018 on the misdemeanor case. And in this case, where his mental infirmities and conditions gave rise to criminal conduct, according to what was documented in the court clinic, then the defendant is remorseful. He's going to speak today, and his remorse is documented in the pre-sentence investigation report. And the last thing I will point out with respect to less likely factors, committed under circumstances not likely to occur. So if you are 22 or 23 when it happened, in the first 22 years of your life, you did not commit any crimes. And then on this day, because you're not taking your medication, you got mental infirmities and conditions, you commit these crimes, these 2 crimes, and now you're restored. What is the likelihood that you're going to do this again if your competency is restored and you're no longer have a mental infirmities or conditions? I think it will be very unlikely that he'll reoffend. The government asked for a consecutive sentence. First of all, you got to find that the consecutive sentence would not be disproportionate to the crime. I think it would be disproportionate to the crime. Because what they're relying upon is not necessarily allied offenses, there's different elements, but they're relying upon a felonious assault and an aggravated robbery, which stems from the same conduct that you saw in that video, which is the person taking the car and trying to escape and trying to get away. And in the process of trying to take the car or commit a robbery, felonious assault occurred. It wasn't intentional. And I think the video proves that. But more importantly, when you look at the other 3 things that you must find, one of the 3 things that you must find to order consecutive sentences, does he have a criminal history that demonstrates that a consecutive sentence is necessary to accomplish the purposes of sentencing in the state of Ohio? No. Was he under the court supervision or monitoring? And at the time, again, has he ever had a chance to be rehabilitated before? And the answer is no. I struggle with the next one. Harm caused by 2 offenses is too great. The only thing I would say about that, he's went through an extreme amount of harm. And I'm not going to diminish what he's gone through by making this argument. All I'll say is that the 2 offenses merge with respect to the conduct that gave rise to both of them. They're not 2 completely separate instances, doing this and doing that, which is typically happens with the one sentences consecutively. So I'll say this, and I think his mother wants to speak. Got a young man who had mental issues. If you look at the pre-sentence investigation report on the theft offense of the other car, he says, "I want your car, isn't it free?" Something's wrong with it. He's not in his right. We have a young man who was not taking his medication. His family will confirm that. You have a young man who stole a car and tried to get away with it. There was no way he tried to hurt that man, but he did. And that's why he's charged with felonious assault. There's a mental condition gave rise to the criminal conduct that's documented. I think a minimum term of incarceration and with the current sentence for the 3 matters would be appropriate. I think a 3-year sentence coupled with the restoration of his mind he's experienced and 1 or 2 more years in prison, I think that would punish him. And I think that would also account the purpose of incarceration. Oh, I have this one. This one I asked this most. Yes, sir.
Your name, ma'am?
Hi, my name is Cynthia Natasha Fisher.
Yes, ma'am. What do you want to say?
I am the mother of Orlando Devon St. Jr. And I just wanted to say to you and to the courts and to the young gentleman who my son offended, that I'm deeply sorry. I apologize. My son he's mentally challenged. He's had a condition. He wasn't taking his medication. And when we were truly remorseful with the day that it happened, I prayed for you. I prayed for my son. And I know he's remorseful. He's changed. Me and my mother, I'm willing to do whatever it takes to keep my son out of harm's way. I live in Louisville, Kentucky with my husband and his younger sister, my daughter, who's 24. She's in North, she goes to NKU. We're willing to do whatever it takes to keep him rehabilitated and in his right manner on his medication. I just want to say again, I'm truly deeply sorry for my son's actions, for him not being on his medications and all the harm that he's caused.
All right, thank you. Mr. Geis, you look like you have something you want to say. You sure?
I did want to say something.
No, I'm sorry.
You got one more?
Yes, one.
I'll come back. I'm gonna come back to you, okay?
I'm sorry, Mr. Scott. Let me hear. Mr. Scott, I'm sorry.
Tell me your name, ma'am.
Juanita Brown.
Ms. Graham.
Yes,
Good
I'm
morning.
the grandmother of Orlando Saints, and I want to apologize for everything that happened. And we know that he was not in his right mind when this happened. And I am a truly child of God, and my church is willing to help rehabilitate, work with Orlando Saints. We have a program at our church that truly helps young people that have problems like my grandson is going through. And I just want to say that I'm sorry, and I really apologize for all that that's done happen. And I love my grandson with all my heart. Grandson. And he was just not in his right manner when he did it, and I'm sorry for what all happened. I'm deeply sorry. And I truly believe that my grandson, Orlando Saints, had learned from what has happened. He's a good person. He made a mistake. He made a mistake. That's all.
All right, thank you, ma'am. Any other person?
I didn't have something to add.
Yes, Mr. Bennett. Before I go to Mr. Saints, let me go to Mr. Geis and then Mr. Saints, the final word.
Your Honor, I also incurred $6,000 damage to my car, which I had
Right.
to pay for. And these are some of the bills from the hospital for Tri-Health and UC, and they total $419,000. Insurance covered most of those. So thank God they did, but they're still going after money supply. But that's right.
All right, thank you.
And that would be the $24,000 we talked to.
Yeah, besides, yeah.
Mr. Saints, come on up. Let me hear it from you.
Say I'm sorry. Was not in my right state of mind.
Speak loud and clearly.
I said I'm sorry. I was not in my right state of mind. I'm sorry, sir.
The only other thing I'll say, and then I'll be quiet. When I first met with him after this happened, he was at it. He was not lucid. He did not hate me in my defense. He was rambling, slobbering. He was incompetent. That's all I have. I don't want people to upset.
Your Honor, thank you. Bias, hate, draconian, disingenuous, and vindictive. I can assure the court that none of those things played into the decision to make the request for 19 years. What we used, the felony sentencing guide, reference guide from the Ohio Supreme Court, and an application of law and fact, and the facts of this case. What is being asked by the defense as a minimum sentence would demean the seriousness of this incident, would demean the seriousness of this crime. The fact that Mr. Geis is going to live with this for the rest of his life, most likely, is handing him essentially a life sentence of pain and suffering.
Can I say something?
Yes, sir.
I have to pass that car wash every single day wherever I go. It just brings back vivid bad memories.
No, you're fine. I think that sums it up right there. What was notably not addressed when the defense was reviewing the factors in consideration, again, that if the court makes a finding that the harm was so great or so unusual, which we believe very strongly that it is that it requires the sentence that the state is seeking.
Thank you. As I indicated before, I do review my cases very thoroughly and go over everything from all the letters that were sent in, the pictures that you sent in. I watched the video many, many times, and that video was horrific. To see how you were just run over and left for dead, I mean, it just made my stomach turn on how you were treated that day. The fact that you died and had to be brought back to life, you know, that goes over and over in my mind. And I know that you are never going to be the same. That from now on, you have a life sentence of pain and the memory, and I'm sure the memory of what happened to you that day will never leave. Sleepless nights,
Nightmares.
rest, and I truly understand that. What I have to do is weigh everything that you went through and what Mr. Bennett said. There is a law that I must follow. You understand? And in reviewing that law and go overing that law over and over again, you know, I am going to make the determination that a concurrent sentence is not justified. That the harm was so great that only a consecutive sentence would be justified in this instance. Now, what is that consecutive sentence? He has 3 charges. He's facing up to 19 years on just the charges. And then we have something where we can add a 50% after that sentence on the highest level charge. That's the Reagan-Tokes law. Okay. So what sentence would be justified in this case? I look at the first incident where Mr. Saints approached a young woman, stole her car at a car wash, told her that the police could not do anything to her. Asked her, was the car free? And she gave up the car. She walked away and let him have the car. He drove that car until it gave out, whether it was from lack of gas or he just crashed it and he couldn't drive it anymore. And then a couple of days later, he decides to go and take another car. This time you were vacuuming out your car, and I saw that in the video, and you got trapped in the door area when he took the car. And when he was backing up, that's when he ran over you. And again, to see that on video, it just brings tears to my eyes, that anyone who see it, it's like You did not deserve to be treated that way. You did not deserve to have someone come up to you when you're just minding your own business, cleaning your car, to take your car and cause that damage, and then not to render aid when he sees your lifeless body there, not to call the police. His only thought was, I need to get out. And when he could not get out the way that he was going because it was closed, he backed up past your body again. Luckily, he didn't run over you again, but he almost did. You can see it in the video. He almost ran over you a second time. But he ran over the curb. People were trying to stop him and he was able to get away briefly, but eventually he was caught. So again, what sentence is justified? Spinning it right. Murderers get less than 15 in this courthouse. We know that they plead to that. The maximum is 15 life, right? And so what do I do? And again, this is not the first time that I've reviewed your case, trust me. I've reviewed it over and over again. Take it home with me at night. I have a lot of sleepless nights, not because of pain, but feeling your pain and making sure that I do the right thing each and every time. As I indicated, I do believe, and I am making the finding that a consecutive sentence is justified. And I'm not going to sentence in the order that they appear on the indictment. I'm gonna leave the less serious charge for last. On the aggravated robbery, the sentence will be 6 years to 9 years in the Ohio Department of Corrections. On the felonious assault, 6 years that will be consecutive to the aggravated robbery. On the theft, 1 year, which will also be consecutive to the other two charges. The aggregate sentence will be 13 to 16 years. The fine on the aggravated robbery will be 10,000 plus court costs. I know he's not going to be able to pay that fine and court costs, but what that does is serve the purpose of if he receives any money in the Department of Corrections that will go to you towards your restitution. Restitution will be set at $25,000.
Because the defendant ended it.
I understand, but I'm making that finding. You can argue that later. But I'm making that finding so that restitution will be paid if he is able to earn anything while he is in the Department of Corrections. Again, he's required to register as a violent offender upon his release. He is subject to up to 5 years of PRC once he is released.
I believe that's mandatory.
That is mandatory. Good thing, Mr. Sanks, is you have an opportunity to prove to me that you deserve early release. So I left that open, that you can work your way depending on your conduct and your rehabilitation at the Department of Corrections into getting an early release. I left that open, but right now your sentence is 13 to 16 years. It's all up to you whether or not you do the entire 16 years. You understand? You have 30 days to appeal my decision. If you cannot afford the cost of the appeal, or an attorney, the state will provide one for you. Anything from state?
No, Your Honor.
Anything from defendant? Mr. Baker?
Thank you, Your Honor. Nothing.
All right, thank you. Remand to the Department of Corrections. Thank you, sir. Thank you. One second on your plea.
Yes, Judge, I just need to check the paperwork and I'll be ready to go.
Okay.
Is that your buddy? That's your buddy?
I have to go the whole time, I'm like.
No, you're not shooting our.
I don't know if we're still recording. She had, I'm like, now.